Please rise for the constitutional court. I call the matter of the President of the Republic of South Africa and others, and Wesiwe and others for hand-down.
Today, the Constitutional Court hands down a judgment in an application for leave to appeal against the judgment and order of the Supreme Court of Appeal, dated 14 September 2022. In the judgment, I will often refer to the parties who share the common names Tshiqi and other parties frequently mentioned using their first names. I do so for the sake of brevity, convenience, and clarity, and do not intend to disrespect any of them. The first applicant is the President of the Republic of South Africa. The second applicant is the Minister of Cooperative Governments and Traditional Affairs. The third applicant is the Commission on Traditional Leadership Disputes and Claims. And the fourth applicant is the chairperson of the Commission. The first and second respondents are Wesiwe, Feziwe Tshiqi, and Lombekiso Makhosatsini Masokuza Tshiqi. The former being the daughter and the latter being the widow of the late amaMpondo Tshiqi. The dispute erupted in 1937 after amaMpondo died without leaving a male issue. This led to competing claims between two of the late amaMpondo's half-brothers, the late Mr. Tshiqi and the late Mr. Nelson Tshiqi. The dispute was statutorily determined when Tshiqi was recognized as the paramount chief of the Eastern Mpondo. It was statutorily determined because it was not determined in terms of the customary law of amaMpondo, but in terms of the Black Administration Act. The dispute re-erupted when Tshiqi died. This time the dispute erupted between Tshiqi's son, Mpondo Tshiqi, and Nelson Tshiqi's son, Tshiqi. Again, the dispute was determined statutorily, and amaMpondo was appointed as the paramount chief, thus succeeding his father, Botha, who was also a paramount chief. In a separate sitting, the Commission concluded that there was only one kingship/queenship of amaMpondo, thus uniting amaMpondo as a Kaukeni and amaMpondo as a Nyandi. The method and procedure of that investigation, the narrative and the findings of that report were never legally challenged and remain extant. In April 2006, Zanozungu lodged a claim with the Commission that he was the one entitled to be the king of amaMpondo. Mpondo contested Zanozungu's claim. He maintained that he was entitled to occupy the position and to be the king of amaMpondo. The Commission held public hearings into the dispute. In January 2010, the Commission made a decision that Zanozungu was the one entitled to be the king of amaMpondo. Thereafter, the President published the recognition of Zanozungu as king of amaMpondo. It is this decision that now lies at the heart of this matter. Mpondo launched an application in the High Court, seeking relief to have the decisions of the Commission and that of the President reviewed and set aside. Mpondo died on 27 March 2013 and was substituted by Wesiwe and Lombekiso. The High Court dealt with the question whether the Commission erred in concluding that Nelson, and not Botha, was the rightful successor to Mpondo in terms of the customary law of amaMpondo. The High Court held that the evidence showed that had it not been for the intervention of the government of the time, and having regard to the living customary law at the time of the dispute, Nelson, who was more popular than his brother Botha, would have ascended the throne. Then the court considered whether Zukisa in any event had a legitimate claim to the throne through the custom of ukungena. The High Court dealt with this issue by asking different interrelated questions. It first asked itself whether ukungena was practiced by royalty in amaMpondo custom. In order to answer this question, it referred to Mpondo's affidavit submitted to the commission during the hearing, where he stated, I quote, if a deceased paramount chief is succeeded by two brothers and leaves no issue of his own, then ukungena union can only be entered into between the widow and the elder of the two such brothers. I close quote. In this regard, the High Court concluded that Mpondo himself had confirmed that ukungena was part of the amaMpondo custom at the time. Next, the High Court determined whether Magini was a great wife in the royal house. The High Court held that the commission found, on the basis of the evidence placed by witnesses before it, that at the time Nelson performed the custom of ukungena, Magini was still the occupant of the great house of Mzinklovu. The elders intended that the ukungena union be held with the occupant of the great house, who at that time was Magini and not Ndlonge's other wife, Mambofani. The High Court found it significant that Botha himself at the time had warned that any ukungena union with Magini would spell trouble in future. The High Court asked whether an ukungena union had in fact occurred between Nelson and Magini. It also accepted that this union had in fact occurred, and that from this union, Zukisa was Zanozuko's biological father, but was regarded as Mandronge's son sociologically by virtue of the ukungena system. The High Court held that for the above reasons, it was unable to find any evidence that the decision of the Commission was either irrational, unlawful, unreasonable, or procedurally unfair, and that it should be set aside. The Court also considered the respondent's contention that the Commission failed to apply the customary law of amaMpondo by failing to consult the people of amaMpondo. It held that there was no evidence placed before the Commission that, in spite of Section 25, 3A, that it had to consult the people of amaMpondo. When Zukisa and Mpondo approached the Supreme Court of Appeal, the Supreme Court of Appeal upheld the appeal and set aside the order of the High Court. It further set aside the Commission's 2010 determination, as well as the President's report and notice on the appointment of Zanozuko as king. In its reasoning, the Supreme Court of Appeal held that the Commission misunderstood its function in the 2010 process in confining itself to the evidence led by Mpondo and Zanozuko and the witnesses who testified at the hearing. It also held that the Commission ignored relevant evidence on how amaMpondo had chosen their leaders at various times in the past. The Supreme Court of Appeal reasoned further that the Commission's finding belied its claim that it took all relevant factors into account, because consideration of public participation and acceptability or fitness of office were ignored. It held that the Commission failed to apply the correct customary law at the time of the dispute, and that the Commission erred in confining itself to only the evidence led by both disputants to the throne, and in failing to incorporate community participation. Regarding the appointment of Mpondo in 1979, the Supreme Court of Appeal held that neither the Commission nor the High Court considered the relevance of the evidence to the effect that Mpondo's ascendance to the throne was not confined to kinship with his predecessor, but was based on a choice made by the community in an election which was held at the instance of the then Transkeian government, which referred the matter to a vote. Then the matter came before this court. Regarding jurisdiction, the applicants submit that this court's findings in Sitao 1 and Sitao 2 confirmed that this matter raises constitutional issues. On the merits, the applicants argued that the Supreme Court of Appeal was incorrect in two respects. Firstly, it deviated from its precedent that dictates deference to decisions or findings of a commission, especially one that is an expert body, such as the one in this matter. Secondly, the applicants contend that by redetermining these findings of the commission, the Supreme Court of Appeal conflated the nature of a review and an appeal. On the other hand, the respondents argued that the commission committed errors of law in that it did not conduct an all-encompassing investigation into the living customary law of amaMpondo. They contend that the commission should have considered the matter using a standard that considers acceptability, fitness to govern, and popularity. In addition, the respondents contend that the Commission adopted an adversarial trial-like fact-finding process and did not on its own investigate the issues before it. They also argue that it confined its task only to the consideration of the evidence and arguments presented to it by both claimants to the throne. As such, the respondents submit that the Commission committed errors of fact on who was the rightful heir of amaMpondo. The respondents further contend that the Commission failed in its duty to investigate and apply the relevant customary law at the relevant times to the dispute. They argue that by applying a strict genealogical approach, the Commission failed to identify the customs governing the amaMpondo, including the central role of community preference and fitness to govern in choosing between viable candidates. The respondents also contend that the Commission ignored evidence relating to Mpondo's support in 2008 and failed to consider whether amaMpondo supported the appointment of Zanozuk and if he was fit to govern. Lastly, the respondents argue that in crafting the remedy, the Supreme Court of Appeal exercised its discretion in the true sense. This court identified the following as the issues before it. A, does the matter engage the jurisdiction of this court? If it does, is it in the interest of justice for this court to grant leave and determine the matter? B, the review test applicable to the findings of the Commission. Did the High Court and the Supreme Court of Appeal apply the correct review test? C, the mandate of the Commission. D, whether the Commission was obliged to follow the living law of the amaMpondo. For what period and what this entails. E, the method adopted by the Commission in its investigation. F, the concept of deference to the findings of the Commission. G, whether the factual findings of the Commission can be redetermined. And H, the remedy. In a unanimous judgment penned by myself, this court finds that this matter engages this court's constitutional jurisdiction and that it raises an arguable point of law of general public importance. As such, this court finds that it is in the interest of justice to grant leave to appeal. Regarding the review test applicable, this court concludes that the application for review was based on perjury and that the specific provision applicable in perjury is section 6(2)(e), Roman 3, and F, Roman 2, CC, and DD of perjury. Regarding the mandate of the Commission, the court finds that the rightful successor to Umngani Mandlonge was never determined customarily, and that the dispute pertaining to the kingship was not resolved according to custom. Therefore, the events that occurred and that gave rise to the dispute or claim occurred way back in 1937, when Umngani Mandlonge died without leaving an heir to the throne. Regarding the issue whether the Commission adopted the living customary law of amaMpondo, this court has found it helpful to first determine what living customary law is. The court accepts that living customary law is a system that is dynamic, evolving, and context-specific, as it adapts to changes in the beliefs and circumstances of the people it applies to. The court then also finds it helpful to determine if the living customary law was considered by the Commission. It deals at length with the evidence laid at the Commission regarding the customary law of amaMpondo. It reasons that such evidence shows that the Commission dealt with the living customs of amaMpondo at length and did not solely resolve the dispute by following the genealogical system. It holds that the Commission considered the fact that the claim by Zanozuko was based on the fact that he was a descendant of the custom of Ungena and the cultural practice of Isifingo performed by his grandparents. He was also the descendant of the candidate who had been identified by the majority of the community in question at 2 meetings as more popular and having the better claim to kingship. The court finds that the contention by Mpondo that the living customary law of amaMpondo was not considered is not supported by the careful manner in which the Commission evaluated the evidence of the parties and the manner in which it arrived at its conclusion. This court then considers the criticism aimed at the method adopted and the process followed during the investigations. In this regard, the court finds it important that there is no criticism that the court process followed was unfair. That there is also no evidence that the Commission did not conduct its own research as it undertook to do. In fact, there is no evidence suggesting that what the acting chairperson of the Commission says they did not happen. It is very important to keep in mind that there was no prescribed method of conducting the investigation. There is also no evidence criticizing the expertise of the members of the Commission. In fact, we know that its 2008 recommendation about whether the kingship resided with amaMpondo as a Kaukeni or as a Nyandeni was accepted. Of course, during the area investigation, the members of the commission consulted the community widely. Nothing suggests that some of the earlier evidence, to the extent relevant, was ignored in the second phase. The court also finds it curious to note that none of the respondents' predecessors challenged the process at the time of the investigation. They participated fully. The method and procedure followed by the commission on conducting the investigation was in terms of its mandate and beyond reproach. There is no basis to find that a mandatory and material procedure or condition prescribed by the Framework Act was not complied with. It cannot be said either that relevant considerations were not considered. The court then deals with whether there should be deference to the findings of the commission, specifically on findings of fact. The court finds it helpful to set out how the courts approach the decision of administrative bodies in review applications. In Mabedi 1, this court acknowledged that our right to just administrative action in Paja, the legislation enacted to give effect to that right, require rigorous scrutiny of the decisions of administrative bodies. But the court cautioned that neither asked courts to substitute their opinions for those of administrative bodies. It also highlighted that it is not required that a decision of an administrative body be perfect, or in the court's estimation, the best decision on the facts. One of the functions of the commission was to take into account and apply both customary law and the customs of the relevant traditional community as they existed at the time of the events giving rise to the dispute or claim occurred. In dealing with the submissions from the disputants, the commission examined in detail the customary genealogical rules regarding traditional leadership and, to a certain extent, popularity. It also considered the impact of a commission established by the colonial government in the Transvaal, the 1938 Commission, which made some determinations regarding the character of Nelson as a potential Umkani. The Commission found that such determinations from the 1938 Commission were not in line with custom. Therefore, although the Commission did not deal to any specific extent with fitness to govern, it is safe to assume that fitness to govern is reflected in popularity. And the Commission was correct in its refusal to place reliance on an assessment of fitness to govern by white colonial administrators whose preference was for pliant traditional leaders. It is not clear to this court why the Supreme Court of Appeal rejected the findings of the Commission. That, firstly, Walter, as the son of the right-hand house, could never succeed as the Umkani, and secondly, that amaMpondo resorted to Ungena to raise a seat for Manfronte's house. The Supreme Court of Appeal failed to show how these findings were out of kilter with the evidence presented to the Commission and the Commission's own research. This failure was primarily due to a lack of acknowledgement that the Commission was an expert body in its own right, like another administrative body. It overlooked the fact that the Commission comprehensively engaged in the collection and evaluation of evidence from various sources and conducted its own research. Another error by the Supreme Court of Appeal was that it ventured beyond the proper scope of its judicial review powers by suggesting that the Commission should have considered a broader scope of evidence to obtain a more comprehensive view of living customary law of amaMpondo. It second-guessed the assertion of the acting chairperson of the Commission, who in his affidavit states that the living customary law of amaMpondo at the time was considered, and how the Commission's reporting evidence are replete with evidence of what occurred at the relevant time. This was a review, not an appeal. A review is different from an appeal. As stated above with reference to appeal, even a difference in the interpretation of the facts placed before the Commission does not entitle a court to set aside the Commission's decision. So long as the Commission's decision is rational and does not suffer from a review ground set out in Section 6.2 of Pattern, a court may not intervene the venue. Having said that, I do not find a basis to find that the Commission committed an error in law or in fact. There is thus no basis to review the findings of the Commission. Regarding the remedy, the parties have approached this court seeking an effective remedy. The parties approached the courts because they were struggling to resolve the dispute amongst themselves. There have been decades of uncertainty for amaMpondo as to who should be their true heir in the show. In my view, therefore, even from a practical point of view, it is impossible to determine who the royal family is without first determining which line of descent, that of Nelson or that of Walker, produces the true heir. An effective remedy in this case is an order replacing the decision of the Supreme Court of Appeal, with one dismissing the appeal against the judgment and order of the High Court. Pondomini and Zanuzuko have passed away, but in November 2018, the President recognized Zanuzuko as king, and this was duly promulgated in the government gazette. Although his successor will have to be identified, this will be done against the background that Zanuzuko was the king. The order of this court will, therefore, leave in place such recognition. Regarding costs, the Supreme Court of Appeal ordered the applicants to pay the respondents' costs. This was in light of the fact that the Supreme Court of Appeal had reversed the High Court's decision. It is common cause that the award of costs is a matter within the discretion of the court. Therefore, I make no order as to costs. I therefore make the following order. 1. Leave to appeal is granted. 2. The appeal is upheld. 3. The order of the Supreme Court of Appeal is set aside and substituted with the following. Roman 1, the appeal is dismissed. Roman 2, there is no order as to costs. 4, there is no order as to costs in this court. I hand down the judgment.